Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer. Day 2 of rapper YNW Melly's murder trial in South Florida brought long periods of testimony from crime scene investigators. The prosecution wants to show the jury why they believe Melly was the shooter inside an SUV back in October of 2018. Melly, whose given name is Jamell Demons, is accused of killing 2 men he called his friends. In October of 2018, Melly's best friend, Cortland Henry, showed up at a Miami hospital claiming his friends were caught in a drive-by shooting and were bleeding out in the car. Anthony Williams and Christopher Thomas had multiple gunshot wounds and were pronounced dead. Henry told officers they were shot at while leaving a recording studio. But when police got there, they said there was no evidence that a drive-by had occurred. Investigators determined the victims were shot by someone in the car, and surveillance showed 4 men inside, including Melly. Police arrested Melly and Henry on 2 counts of first-degree murder each. They are being tried separately and have both pled not guilty. The prosecutor walked one investigator through the photos he took of the Jeep where Thomas and Williams were killed. We want to warn you, some of the photos do show blood inside the SUV.
That is the area between the front passenger seat and the door jamb for the front passenger door.
Okay. Next photo, what are we looking at here?
That is the front passenger side floorboard.
Moving on here, the seats, did you manipulate them in any way before taking this photograph?
No, I did not.
Moving on into the next photograph, what are we looking at there?
Those are gold caps for teeth.
And so it's clear that that's a close-up photo from this rear passenger door. Is that a correct statement?
Yes, that is correct.
What are we looking at in this photo?
That is a spent projectile.
So I'm going to go back a photo. Is that the same projectile that is down here?
Yes, it is.
Going forward again, what are we looking at in this image?
That is the rear passenger side floorboard and the items that were found there.
Continuing to the next photo, what are you documenting in this image?
In this image, you can see the partial back of the front passenger side seat, the, again, floorboard of the rear passenger side floorboard, the rear passenger side seat, and a projectile hole that you can see defect onto the seat.
And so I'm going to zoom in on an area. Can you explain what you're talking about, the projectile hole?
Yes.
And you can use the screen to touch if you're to draw attention to certain areas.
I observed the defect in the seat that is later on gone into detail.
Okay. What are you documenting in this image?
This image shows the trunk which had been opened, and in the photograph you can see the car manual and a jacket.
Did you disturb any of the glass? Did any of the glass move when you were opening that trunk?
Not that I recall.
All right, let's bring in my co-host, former trial attorney Terry Austin, and our very special guest, former homicide prosecutor Bernardo Villalona. Terry, a lot of today's testimony may have seemed really dry, not just to some of our viewers, but probably some of us as well. But why is it necessary to go through each and every piece of evidence in so much detail?
Well, because under the federal rules of evidence, you have to make sure that obviously it's relevant, and all these photos with this particular witness were relevant, but you have to lay a foundation to authenticate each and every photo. And in order to do that, you have to ask the individual, did you take the picture? Is this a fair representation? Is it an accurate representation of the scene at the time? If all of that goes well, then it can be introduced. But the process itself is also tedious because you have to first ID the piece of evidence, and then you have to show it to opposing counsel, and then you have to show it to the witness, and then you lay that foundation, and then the judge, you may get an objection and the judge has to rule, then you have it into evidence and it's published. So it's a process.
Yeah, and those are the same rules that the states have. I always tell people, hey, the foundation of a home isn't sexy, but if it's cracked, you're not going to want to buy that home. It's probably the same thing here. Bernardo, some of the photos of the crime scene showed graphic footage of the car containing bloodstains. There was an objection by defense at one point. Do you think the photos could be prejudicial to the jury?
So you have to think, with these photographs, the judge had to weigh its probative effect versus its probative value versus its prejudicial effect. Of course, it's prejudicial in the sense that it leads to the guilt of the defendant. However, it's relevant to the sense that the prosecutor had to lay out what did the crime scene look like, and also where the pieces of evidence were located, especially in the case where the defendant claimed that the injuries occurred as a result of being shot at. This would tend to dispute the car being as a result of a drive-by, but instead of that, the shooting took place inside. So, of course, the probative value definitely outweighs the prejudicial effect.
Yeah, it gives us a lot more information about what happened in that car. Well, Law and Crime has a reporter, Bryson Paul, inside the courtroom covering this trial for us. He's able to give us some insight into what the cameras don't see. Let's take a listen.
You definitely notice the animosity between the victim's family and YNW Melly's family. Both have looks crossed back and forth at each other on multiple occasions. As evidence and video shows of the now deceased victims, you can see the victims' families even look directly at Melly with a disdain look on their face. You can see when they have the videos of Melly and Melly and his group of friends walking around, even leading up to the murder, you'll see Melly's mom look over at the victim's family to see what their reactions are. And even at one point in time, when we were about to break, the victim YNW Juvy's mother even got up in the middle of the gallery and stared directly at YNW Melly until he looked at her. He's definitely not looking forward to looking at the deceased. He actually refuses every time, whether they're alive in the video or not, he refuses to look at them in the video. He actually just turns away, either turns down his head or consorts with his counsel.
We're finishing today's show in Green Bay, Wisconsin. Taylor Shabazz appeared in court for a motion hearing as a judge weighs whether she's competent to stand trial on murder charges. Shabazz is pleading not guilty by reason of insanity to the gruesome death of 24-year-old Shad Therian last year. The defendant allegedly confessed to investigators that she choked him with a metal chain during sex, molested his corpse, and dismembered his body. The victim's remains were found scattered throughout his mother's home and in the defendant's van. Tuesday's hearing addressed defense motions to suppress certain evidence in the case, more specifically, her confession to police. The defense believes that Miranda rights weren't given before some of the statements and that she was also reportedly under the influence of drugs. Therefore, it could not have been a voluntary confession. One witness who testified during the hearing was a defense pharmacologist expert. He evaluated the defendant earlier this month and described what she said about drug use on the night of the murder.
Taylor met with Shad. There was drug use, methamphetamine use. Shad was smoking methamphetamine. Taylor was using intravenous methamphetamine, which was her usual method of administration, but that evening she also smoked methamphetamine. There was a reference to Shad being injected with trazodone. May or may not have been a reference to Taylor injecting herself with trazodone. There was an alleged asphyxiation. Shad died. There's an alleged dismemberment. Approximately a day later, Shad's dismembered body was discovered in his mother's basement. And shortly thereafter, several hours after that, police found Taylor, detained and arrested Taylor, and subsequently interrogated her, questioned her, and she was detained to the Brown County Jail. So I took a thorough history of her drug use, both chronically and up to the incident. So yes, and she did admit to using principally methamphetamine, practically daily, if not daily.
Bernard, the defense wants that statement by Sakchaser that she made to the police to be suppressed for failure to give Miranda warnings. We know them. You have the right to remain silent. Anything you say can and will be used against you. But also I'm kind of curious about this intoxication argument. What is the likelihood of the success of these arguments?
Exactly, Brian. So if a judge is to find that she wasn't able to knowingly or voluntarily waive her Miranda warnings, her right to remain silent, then a judge has no choice but to suppress the statements. So in terms of her intoxication, it plays a huge role in determining whether she was able to knowingly waive her right against giving any statement. So a judge is going to take that into account, because if you are so intoxicated or under the influence of whether narcotics or under the influence of alcohol, then your mind supposedly cannot process or understand what is being told to you, and you can't fully process and acknowledge that you're knowingly waiving your right against giving a statement or against self-incrimination. And if that is the case, the judge has no choice but to suppress the statements, but also she'll get a second bite at the apple at trial, because that same type of jury instruction will be given to the jury to make that determination.
Yeah, if it comes in, she'll be able to argue, hey, I was so high, I was so intoxicated, you can't believe anything I would say. It could be a possibly good argument. Terry, the attorney for Sakchaser requested a second competency hearing. The judge previously denied the request, but could that request be reviewed?
It could be reviewed and it could be renewed, and I think it should be. I think defense counsel really has a good argument here. She was originally looked at way back in November, and the judge made his decision in March. And what the defense is arguing is, look, so much has happened between November and March and now, so he should renew that. She is, I think, having some mental issues. The fact that she attacked her attorney, that's one incident that should be considered. And I think even if you don't use it for competency, it could be used as far as her mental illness at trial.
Yeah, you cannot participate in your defense. Fighting your attorney could be one of it. Bernard, Terry, thank you, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.